I've been asked to use the podium as much as possible for audio reasons. All right, so Judge, I spoke with Sergeant John Jenks a few minutes ago and fleshed out the issue a little bit better. He indicates that 15 or 20 years ago, they were first talking about McCombs having a violent reputation, that they would discuss basically if they were dealing with the guy to be careful and have backup, that he was one of the people that if they were dealing with him, they would want to have backup. Sergeant Jenks has not been assigned to the North End in about 4 years. But as of when he left the North End, and they had gone a period of time without having much dealings with Mr. McCombs, but that it was still a situation where if he were dealing with Mr. McCombs and backup was available, he would want to have backup before dealing with him. The discussions were, it sounds like, generally limited to those assigned to the Northern District because they were the ones that would have had dealings with Mr. McCombs. So the question at this point is going to be whether or not that evidence would be allowed to come in. And if so, then obviously I'll do a amended reciprocal and list him as a defense witness and then call him in the case.
State have a response.
Yes, Your Honor. Go up there. Give me one moment, Your Honor, to collect myself. Yes, Your Honor. The state would argue against admitting the reputation evidence, and it's basically, we got three prongs on that, Your Honor. Going first with State v. Smith. In that particular case,
Which one?
what is it, the 660?
You give the whole set. I know we talked about
Yes,
that.
Your Honor. State v. Smith, 606 Southern 2nd, 641. And in that one, the state believes it differentiates the two different types of evidence. You already acknowledged the specific facts or specific act violence and then the reputation. And the reputation is only shown when you're arguing for the victim's conduct. And as far as the state is aware, the entire argument from the defense's side and their argument is that it was the reasonable fear based on the state of mind. And when the state of mind is involved, it is the specific act violence known by the victim or by the defendant that can be admitted, not the reputation for violence, Your Honor. That is, we believe, also supported by Munoz v. State. That's 45 Southern 3rd, 954. And in that one, I apologize, I'm getting there. It again differentiates between the two and says that the defendant's prior knowledge of the victim's reputation for violence is irrelevant because the evidence is offered to show the conduct of the victim rather than the defendant's state of mind. And it very specifically differentiates the conduct of the victim versus the state of mind. So reputation is not used when you're talking about the state of mind of the defendant. So that's prong one. Number two, we go into largely Gallo v. State. And that talks about the reputation testimony has to be drawn, is sufficiently, I apologize, I'll say the court case too, Your Honor. That is Gallo v. State, 183, Southern 3rd, 1079. And that's talking about the reputation testimony has to be sufficiently broad to provide the witness an adequate knowledge to give a reliable assessment. The reputation evidence must be based on discussions among a broad group of people so that it accurately reflects the person's character rather than a biased opinions or comments of a narrow segment of the community. And dealing with the narrow segment goes to our final part why we don't believe this should be admitted is Parker v. State. That case number is 458 Southern 2nd 750. And in that one, Your Honor, it's dealing with a witness credibility issue, and they brought in reputation for truthfulness. And it was by a police investigator who was talking about that when the person was incarcerated, they were known for not being truthful. And the court found that the criminal justice system is neither neutral enough or generalized enough to be classified as a community, or that the officer in that system is equipped to provide an unbiased and reliable evaluation of an inmate's general reputation for truth-telling. And we believe that would also fall in line here, Your Honor, where a small set of officers in just the Northern District, or northern part of Okaloosa County, is not broad enough and not unbiased enough to be reliable to fit Gallo v. State, Your Honor.
All right, so obviously we took a break so I could do a little bit of research on this issue as well. I also found the Parker case. In fact, I had highlighted the exact quote that you had just made, Mr. Sheik. I also found Dean versus State, which is 843 Southern 2nd 926. That's a 5th District Court of Appeal case. Not to get too far into it, but basically a detective testified regarding someone's reputation, and in that case specifically said it is generally inappropriate for one who is a detective and who gains his knowledge of a person's reputation solely through his official position to be allowed to testify in this respect. Basically saying that, and in fact I found another case, I'll have to find the exact site, but it was about a prosecutor who was to testify regarding someone who he prosecuted for perjury, and that assistant state attorney should not have been able to testify because he or she had only learned of the reputation evidence through his or her professional capacity as a prosecutor. So I think the concern regarding general reputation is that the law enforcement community in general, let alone the north side of Okaloosa County District, is not broad enough nor diverse enough to be considered the community for purposes of reputation in the community. I've also reviewed Florida Statute 90.404, which is the character evidence statute, as well as 90.405, which how to prove character. I can just pull that up quickly. I think this is somewhat what we discussed yesterday, related to a somewhat similar issue, but different as far as reputation evidence with Mr. McCombs. Florida Statute 90.405, entitled Methods of Proving Character, states paragraph 1, reputation, when evidence of the character of a person or of a trait of that person's character is admissible, proof may be made by testimony about the person's reputation, and 2, specific instances of conduct when a character or a trait of character of a person is an essential element of a charge, claim, or defense. Proof may be made by specific instances of that person's conduct. I think in theory, the alleged victim's reputation is admissible, but it's how it's proved that really matters in this particular instance. So as far as reputation, from what I've heard, has been proffered, and I'll certainly give either side all the time they want to proffer evidence by having the witness be brought to the stand and testify outside the presence of the jury regarding reputation, what community that reputation has been formed in, But in the case law that I've read in the relatively short time I've had to do that this morning after being advised of a somewhat late breaking issue, I don't think law enforcement in general, let alone one small segment of it in one geographic area, is necessarily diverse enough in order to be considered reputation evidence. And as far as specific instances of conduct that can be used to prove character, a trait of character, but it was my reading in the case law that was provided yesterday and researching again this morning that for specific instances of conduct to be used to prove character, basically in this case, the defendant, Mr. Norris, would have had knowledge of those specific instances of character, and having not yet heard that in any way, and in my knowledge of the facts that have come out during yesterday's proffers, as well as previous things that were cited from other hearings we've had, I just haven't heard that at this point. So, Mr. Williams or Mr. Maddox for the defense, I'm not sure if you want to argue anything more or potentially proffer any evidence. And then my final concern is in particular with the officer who's been discussed today, is that officer works in the courthouse. And I don't recall Sergeant Jinks being in jury selection yesterday at any point, but my concern would be if he's had any contact with any of the jurors during the course of even shuffling from room to room, from jury assembly up to the courtroom, up to the jury room, because obviously if a potential witness has had contact with a juror, we've got a whole separate problem.
Judge, from speaking with him this morning, my understanding is that he's assigned over in the injunction hearings, and so he's not likely to have had contact with any of the potential jurors.
Well, yesterday is what this is more my concern.
I don't recall seeing him yesterday, but we'd have to ask him about that. It was not an issue that I was aware of, or I think the state was aware of while we were doing jury selection yesterday, so we would.
From everything I've heard, this was a phone call that somebody got at 8 o'clock this morning. So nobody knew about it yesterday.
It sounds like there was a discussion with another prosecutor yesterday afternoon when we finished up, and then that prosecutor made a phone call probably this morning. But I do want to proffer his testimony just so that the record's protected in the case this becomes an issue on appeal.
And Your Honor, if I may, just to address Parker v. State and Dean v. State as the court has cited, I believe one of the primary concerns, at least in my reading of Parker v. State, is not so much necessarily that it was an officer per se, but that the community was described as the criminal justice system. And the context of that community was really that he was learning this information about an inmate while he was taking part or was employed at the jail, or at least that was what was argued by the state. So I think that's what the concern is there. I don't think necessarily the court is saying there that the law enforcement community is, at least not in Parker v. State specifically, prevented from testifying about reputation evidence. I think the concern there was the context of which the community was established there. And then, yes, the court did describe it as the criminal justice system, but I don't think that stands for the principle that the law enforcement community in general is completely barred from testifying in every situation, especially when it's critical to Mr. Norris's defense. And again, we are dealing with an inmate there. And then in Dean v. State, Your Honor, as cited by the court, there were large concerns cited by the court there about how the knowledge was gathered, and in fact the lack of knowledge, which I do believe we can establish potentially a sufficient basis for the knowledge to be based upon, and then for the reputation evidence to potentially come in. Again, obviously we'll proffer the testimony, I believe, to the court, and then revisit that issue later, but I did want to point out those concerns, Your Honor. I think that in Dean v. State, one of the primary concerns was the limited knowledge and the limited basis for which the reputation testimony was being offered. And then in Parker v. State, it's how the community was established, not so much that the law enforcement community in general, at least not in Parker v. State, is completely prohibited from testifying about reputation evidence in every situation.
You're prepared to do your proffer now?
Judge, yes, if we could ask Court Security to notify Sergeant Jinks and ask him to come up and join us.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, take a seat. Make sure you speak into that microphone. Go ahead with your questioning, Mr. Williams.
Thank you, Judge. Please state your name and occupation for the record.
John Jinks, Deputy Sheriff.
And
What are your rank within the Sheriff's Department? Sergeant.
Where are you currently assigned?
Currently assigned to the Okaloosa County Courthouse.
All righty. Were you previously assigned to the Northern District?
Yes, sir.
Would that be the area that would include Holt and Baker? Was it over here, Escambia Farms?
Yes, sir, it would.
Okay. When did you leave or stop working in that area and go somewhere else?
I believe January of 2021.
All right. Did, during the course of your working in the Northern District, did y'all have any kind of like muster back then?
Yes, sir.
Okay. And did y'all discuss people to be careful of, people's to be concerned about, people to be sure you always had backup with, that sort of thing?
Yes, sir. I can't say that it was always what we call shift briefing, but the deputies did discuss that.
All righty. Now, did Joseph McComb's name come up?
Yes, sir.
And what was, were you made aware of Mr. McComb's reputation for violence?
We believed within the sheriff's office that he did have a reputation for violence.
All right. Did y'all, as a result of that, take special precautions when dealing with Mr. McCombs?
There are numerous people that when we heard the name, we would always try to have a second deputy available.
Was Mr. McCombs one of those folks?
Yes, sir.
All right. Now, as of the time when you finally left the Northern District, and just get us there a little quicker, I think you went from the Northern District down to Fort Walton?
Yes, sir.
Okay. When you left the Northern District and went to Fort Walton, as of that time, was Mr. McCombs still someone that you would make sure you had backup if backup was available?
I would still have been cautious, but we weren't hearing his name as much.
Okay. Now, did you obtain any reputation evidence about Mr. McCombs other than from other sheriff's deputies?
I believe that I worked some calls involving him, but I do not have any recollection of the actual facts of the event.
Do you recall whether or not other people who were not law enforcement came to you and basically told you to be careful of the guy or something like that?
I can't speak for that because I didn't really interact with the community that much. That was,
Yes, sir.
I handle my calls.
All right. Court will give me one moment. All right, now we've established that the area where Mr. McCombs lived was the Escambia Farms area.
Yes, sir. Mormon Temple Road, I believe.
All right, and do you recall whether or not Mr. McCombs had a reputation within that community?
I can't really speak to that. My friend said his friend said it didn't really intersect. So I wouldn't know what the community thought of him.
Okay. Do you have any information about his reputation for violence in any community outside of the law enforcement community?
No, sir.
Okay. Sergeant, do you recall personally you ever encountering Mr. McCombs?
I have dealt with him, yes, sir.
Okay. And how did those encounters go?
I never had to fight him.
Do you recall him doing things like bowing up to you or?
Sir, if it's been 15, 20 years ago, I probably would have remembered if he had bowed up on me, though.
Okay. During the course of those occasions, do you recall speaking to anyone that described McCombs as violent to you?
If anyone did, I don't recall.
Do you have any evidence of Mr. McCombs' reputation outside of the Northern District law enforcement community?
No, sir, I do not.
Judge, I believe that's all the questions that I have.
Thank you, Mr. Williams. Does the state have any questions for Sergeant Jinks for the purposes of the proffer?
Just a very brief follow-up, Your Honor. Just want to make sure that we're absolutely clear about your testimony, Sergeant Jinks.
Yes, ma'am.
All of the information that you gathered about Mr. McCombs was through your employment at the sheriff's office.
Yes, ma'am. I do not know him personally.
And so you do not know anything about what the community thought of Mr. McCombs as a whole.
I don't recall ever having a conversation with a community member that expressed any violent tendencies.
Thank you. That's all I have.
Anything else based on that, Mr. Williams?
No, Your Honor.
Thank you, Sergeant. For the record, Sergeant Jinks has left the courtroom. I've listened to his proffered testimony. It hasn't changed my previous ruling as far as whether or not that testimony would be admissible based on his testimony. Again, I think reputation of an alleged victim in a case is potentially admissible. It's, again, how 90.405 says it can be proven. I don't think a small segment of law enforcement who've learned the knowledge that they have of the alleged victim, Mr. McCombs, as far as his reputation that they've all gathered through their professional work, is sufficient to reach the level of kind of general reputation for the community. I don't think that community is broad enough and diverse enough as required by the case law, specifically the Parker case and the Dean case. And as far as any specific instances, I didn't hear Sergeant Jinks testified any specific instances of violence. But again, as shown in the case law we discussed yesterday, person who's dealing with Mr. McCombs, in this case Mr. Norris, would have to have knowledge of those things has not been testified to nor proffered at this point. So my ruling is the same. Sergeant Jinks's testimony regarding reputation of Mr. McCombs is not admissible at this point.
Yes, sir.
Anything else that we need to take up before we bring in the jury?
Not from the defense, Judge.
Nothing from the state, Your Honor.
It's my intent at this point to read jury instructions 2.1, which is just the preliminary instructions, and then 2.2, which is the note-taking section. Obviously, the jury will be sworn once they first arrive, and then we'll proceed to opening statements.
Your Honor, if we may address scheduling today really quickly before we bring the jury in, just so.
Just to make sure, too, we've got some people in the audience. Do we have any witnesses who are present? Okay.
Judge, I'll invoke the rule.
So anyone who's present as and intended to testify as a witness is going to have to be excluded out to the hallway. Hold on just a second. I've got a couple other things to tell you. Do not talk to anyone else about your testimony or any testimony that's gone on in the courtroom outside of your presence. Obviously, the lawyers who are handling this case can speak with you, but otherwise, if someone tries to talk to you about your testimony or tell you anything else that's going on in this courtroom, make sure to tell our court security team, who will bring it to my attention. Anything else?
We may approach about scheduling real quick.
We're going to ask those witnesses to be excused to the hallway, please.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries.
Hands, please. All right, good morning, everyone. Start off by thanking you for being back and also apologizing for the delay. As I told you yesterday, we hope to get started around 9 o'clock due to some things we had to still finish up before we could get the trial actually started. We had a little bit of a delay this morning, but we still have plenty of time to get through everything this week. So I'm just going to go through with our preliminary instructions, and then I'm going to allow for the lawyers to make their opening statements in the case. Members of the jury, you've been selected and sworn to try the case of the state of Florida versus Ronald Franklin Norris. This is a criminal case. Mr. Norris is charged with second-degree murder with a firearm. The definition of that crime will be explained to you later. You must decide this case based on the evidence presented in the law that I give you. Evidence consists of the sworn testimony of witnesses, exhibits admitted into evidence, and anything that I tell you to consider as evidence. The state's charging document, which is called an information, is not evidence and is not to be considered by you as proof of guilt. It is my responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Mr. Norris in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may be introduced as evidence. After the evidence has been presented, the court will give you instructions on the law, and the attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, the alternate jurors will be released and you will retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instructions of the law that I give you. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or the lack of evidence and the law. Jurors must decide the case without distraction and only on the evidence presented in the courtroom. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, a cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. You may not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtained is proper for the case. The parties likewise will have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. You are also not permitted to communicate about the case with anyone, including your spouse, family members, friends, neighbors, or even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication such as emailing, text messaging, posting information on social media or a website, or any other form of communication. During the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. It is important to remember that the prohibition on communicating about this case applies during these recesses, whether you are in the courthouse or elsewhere. If at any time you find yourself in a situation where others are discussing the case in your presence, leave that situation at once and immediately report that matter to the court deputies who will advise me. You cannot have any cell phones, tablets, laptops, or other electronic devices in the courtroom. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and an inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, the defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted to consume as little time of your time as necessary for a fair and orderly trial of the case. And then one more thing about note-taking. As y'all see, you'll have notepads that were provided to you as well as pens. If you'd like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with a notepad and pen for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the court deputies will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the court deputy will deliver your notes to me. They will be destroyed and no one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. And there's a state prepared to give its opening statement.
Yes, Your Honor, thank
You
you.
may proceed.
I'm not playing. I'll put him in the hospital or the morgue. The evidence in this trial will show that approximately 45 minutes before Ronald Norris placed a shotgun to Joe McComb's head, that Ronald Norris made this statement to law enforcement. "I'm not playing. I'll put him in the hospital or the morgue." The evidence will show that Ronald Norris was so angry with his wife that when she came into her own house, the evidence will show that Mr. Norris had torn up. She came in to get her stuff, and she brought her cousin Joe McCombs with her. The evidence is going to show you that Ronald Norris walked down the hallway with a shotgun immediately towards his wife, Tracy Smith, and Joe McCombs, and then he put the shotgun to Tracy Smith's head first, and then he moved the shotgun to Joe McCombs' head. And then as Joe McCombs tried to move that shotgun away from his head, Ronald Norris pulled the trigger. The evidence is going to show you that in order to hurt Tracy Smith, Ronald Norris hurt her cousin. The physical evidence presented in this case is going to show you that this is second-degree murder. The state asks you to consider not the amount of evidence that's presented, but the quality of the evidence. The state asks you to look at the evidence in this case and weigh that evidence, the physical evidence that you're going to get, against the testimony of the witnesses, and to consider who's given different versions of events, who's testified untruthfully, and who has the most to gain by their testimony. At the end of this trial, the state will ask you to look at all of the evidence and consider whether this is a case of self-defense. And the state believes that the evidence is going to show you that this is a case of an angry man who shot a man and meant to kill him at the time, that this is not a case of self-defense. The state will then come back and ask you, because of the facts and evidence in this case, because he threatened him about 45 minutes before he shot him, to return a true and just verdict of guilty. Thank you.
Williams, opening for the defense.
Right now, you've heard very briefly one side of the story. And like most stories, there are two sides to the story. And the state's alluded to it a little bit in talking about self-defense. You know, the biggest thing that I want you to take away at these opening statements is that never during the entire course of this trial should you consider anything that I say or that Ms. Sandler says or either of the two lawyers assisting us to be evidence. It's not. Evidence is going to come from that stand over there, not from these podiums. We're lawyers. State attorneys are lawyers too. We're lawyers. We're putting forward our clients' positions. We're putting forward what we think the evidence is going to show. Now, I like to think of opening statements as being like, I like to think of a trial as being like a jigsaw puzzle. The pieces to that puzzle are the evidence. The evidence is going to come from that stand. Some of it's going to be testimony, some of it's going to be physical evidence, but that's where the evidence is going to come from. And when the evidence is based on what a witness says, you're going to have to ask yourself whether or not you believe that witness. And the judge at the end of all this is going to read you some instructions on things that you can use to determine whether or not you believe a witness. Now, all of us at some point or another have put together a jigsaw puzzle. And so we all know that it's helpful to have that picture on the front of the box, because it tells you that the blue piece, the light blue piece is part of the sky, the dark blue piece is part of the ocean, the green piece is part of the grass. It helps give you an idea how to put it together. And that's how you should view what we say. And then at the end of the case, we'll give closing arguments and we'll tell you how we think you ought to put the jigsaw puzzle together. But ultimately, that's going to be your decision. Now, your decision, though, has to conform with the rules and the instructions that the court gives you. But here's the thing, the court's never going to tell you how to decide. The court's going to discuss things that you have to consider, and it's going to discuss how convinced you have to be. It's going to discuss what reasonable doubt is. I'll give you a little heads up. It discusses reasonable doubt by telling you what it isn't. And it's going to discuss where reasonable doubt can come from. But ultimately, it's going to be your job to decide what testimony you believe, what evidence you believe, and how it applies to the law. I, too, am going to talk for purposes of opening statement in very broad terms. I think the evidence is going to show that the relationship between Mr. Norris and Tracy, his wife, was not a good one. I think the evidence is going to show that Mr. Norris was afraid of what Tracy might do or what Tracy might have others do on her behalf. And I think the evidence is going to show that Mr. Norris acted to protect himself based on what he believed was likely to happen, everything under the circumstances. Now, I will say this. The evidence is also going to show that this happened way back in August of 2021. I think you're going to find that people's memories are not perfect over that period of time. I think you're going to find that different people in the same position, as sometimes happens, see things differently just based on their perspective, where they're looking from physically, and where they're looking from in terms of their own state of mind. And I think you're going to have to take all of that into effect when you weigh the believability of each witness. So I'm going to suggest that you understand that there's probably going to be some minor differences in people's testimony over time. Again, this was a long time ago. Both of us will get the chance to talk to you again at the close of the case. For right now, just keep in mind, the state goes first, and then we go. I'll ask questions during the course of the trial to elicit information from the state's witnesses that I want to elicit. But in the end, you cannot begin to form an opinion until after you've heard all the evidence. One, it just doesn't make sense because you haven't heard all the evidence yet. And two, because you've been instructed not to. So I just ask that you obey your oaths as jurors, be fair, listen to everybody, but be critical when it is appropriate to be critical, and to look at things from a critical standpoint in who's telling me the truth, who's remembering well, who's not telling me the truth, things along those lines. Thank you very much.
You ready to call its first witness?
Yes, Your Honor. The state would call Investigator Tyler Colonna. Does the court mind if I turn this toward? Thank you.
Of course I don't. So. I'm sorry, Madam Clerk, go ahead. Go ahead, Ms. Hanna.
Good morning.
Good morning.
Can you state your name for the record?
Tyler Colonna.
Where are you employed?
Tyler Colonna,
Where are you employed?
Okaloosa County Sheriff's Office.
What is your position there?
I'm currently an investigator.
How long have you been there?
Since June of 2018 at the Sheriff's Office.
And on August 25th of 2021, what was your position at the Sheriff's Office?
I was a deputy sheriff in the North End, field training officer.
Is that in Okaloosa County?
Yes.
And were you involved in a call that day involving Ronald Norris?
Yes, ma'am.
Approximately what time was that?
Oh, I couldn't tell you.
Was it in the daytime?
It was daytime, yes.
Was it earlier in the daytime?
I believe so, yeah.
Okay, somewhere around lunchtime, maybe?
Sounds, yeah, that sounds right.
Did you make contact with Mr. Norris?
Yes, ma'am.
What was his demeanor?
Upset, a little frustrated over the situation that was taking place.
Okay. And what kind of home was it that you responded to?
I think it was a mobile home. It had a add-on kind of room built onto the side of it.
Was that on Wilkerson Bluff Road?
Yes, ma'am.
Did you do a walkthrough of that home?
I did.
And when you were doing that walkthrough, were you wearing your agency-issued body camera?
I was.
And was that camera operational?
Yes, ma'am.
And did that camera record your interaction with Mr. Norris?
It did.
Okay, and when you got back to your office that day, did you upload that camera footage to evidence.com?
Yes, ma'am.
And would that camera footage be a true and accurate representation of your interaction with Mr.
It would.
Norris? And would that camera accurately reflect the state of the home that you walked through?
Yes, ma'am.
Your Honor, may I approach the witness? Let the record reflect I've shown the defense. State's Exhibit 2.
Yes. No. Well, actually, that's not established.
Investigator Colonna, I'm showing you what's been marked as State's Exhibit 1. Recognize this?
I do.
How do you recognize it?
That's from my body camera.
And is this a still from your body?
It is.
Is this a true and accurate representation of the 5th, 2020?
Yes, ma'am.
Has it been changed or altered?
No, ma'am, not at all.
Your Honor, the state moves to admit State's Exhibit 1.
Any objections?
No, Your Honor.
State's Exhibit 1 will be admitted without objection.
Your Honor, may I use the...
I believe so. I think it's in podium. Is it in podium?
Record reflect, I'm showing the witness what's been marked as State's Exhibit 2.
I do.
How do you recognize it?
It's from my body camera.
Is it a true and accurate representation?
Yes, ma'am.
And this is a still from your body camera, August 25th, 2020.
It is.
Has it been changed or altered?
No, ma'am.
Tell us what State's Exhibit 1.
Looks like I'm standing in the kitchen. I see Mr. Norris here. I believe this gentleman, I don't remember his name, but standing in the doorway was his grandson, maybe. And I see maybe a china cabinet window.
Was the china cabinet broken?
No, ma'am, not at that time.
Looking at in State's...
That looks like the porch leading out of the house, looking out onto the yard.
Okay, was the porch covered with debris?
No, ma'am, it's not covered with debris, just a couple items on it.
Okay.
Which one?
State's Exhibit
I'm not sure 2 was admitted.
1. Sorry, state moves to admit Exhibit 2.
All right, any objections as to State's Exhibit 2, Mr. Williams?
No, Your Honor.
State's Exhibit 2 will be admitted without objection.
Thank you, Your Honor. May I publish?
You may publish.
This morning. Investigator Colonna, is this State's Exhibit 1?
Yes, ma'am.
Is that the inside of the trailer?
It is.
Is that the kitchen?
Yes, ma'am.
And at the side, is that Mr. Norris?
It is on the right side, yes.
Can you identify Mr. Norris?
Yes, ma'am. He's right behind you on the. Yes, ma'am.
Let the record reflect that the witness has identified Mr. Ronald Norris.
Records shall reflect.
Investigate.
Yes, ma'am.
At the outside of the trailer?
Yes,
Okay, and is that your patrol car
it is.
in the background? And after you spoke with Mr. Norris, did you close the call?
Yes, ma'am.
I'll tender the witness, Your Honor.
Cross-examination, Mr. Williams.
Do I'll go up and get him. All right, so you were out there on what we're going to probably wind up calling the first call for service.
Yes.
Okay. And during the time that you spoke with him, did you see him brandish any weapons or talk about hurting anybody?
No, sir. He didn't talk about anything like that.
Okay. Now, did he mention his wife having a pistol?
I don't remember that. He may have. I don't remember that though.
Do you recall giving a deposition back on September 25th of 2024?
Yes.
Okay. Do you recall being asked that question in that deposition?
I don't. I'm
All
sorry.
right. If I showed you a transcript of that deposition, would it refresh your recollection?
Sure.
Thank you. Your Honor, if I can approach.
Okay. Yeah, that looks accurate.
So, do you recall? Do you recall whether or not his wife having a pistol was mentioned?
Yeah, it sounds like it. Yeah.
All right. And you recall that he mentioned that he still had a shotgun?
Yes.
Okay. Now, you had, is it pronounced Hahn?
Yes. He was my trainee at the time.
Okay.
Deputy Hahn.
And he was with you?
Yes, sir.
All right. Did y'all have any communication with Tracy or Mr. McCombs on this occasion?
No, sir. We did not.
All right. Now, do you remember being shown a fire pit?
Fire pit? Yes.
Okay. Do you recall that there being any property in the fire pit?
Yes, sir.
Okay. What was it?
I believe we talked about a tree stand, deer stand, or something like that. Maybe a coffee cup that he pulled out of there.
Okay. And at the time, was that all pretty much embers?
Yes, sir. It was burned.
Or ash?
Burned pretty good. Yes, sir.
Okay. All right. Now, the two photographs from your, or stills from your body cam, that's showing two particular areas. And the viewpoint from your body cam is basically only what's right in front of you or what you deliberately kind of angle so that the body cam picks up, correct?
Yes, sir.
Okay.
Just whichever way my body is pointing at the time.
Do you recall seeing any broken glass?
Not that I remember.
Do you recall why you were dispatched out there?
I want to say it was because whenever he got home,
Well, you don't go into what other people told you, but I mean, do you remember the nature of the dispatch?
because his house had been vandalized, basically.
Okay. Judge, that's all the questions I have at this time.
Redirect, Ms. Sandler.
Investigator Colonna, when you went out there, did Mr. Norris spend the majority of his time complaining about his wife?
Most of it, yes, ma'am.
And you said earlier that you closed the call, correct?
Yes, ma'am.
Did you determine a vandalism occurred?
Basically, we kind of concluded that, with the two of them being married at the time, there wasn't much that the sheriff's office could really do about destruction of any property because it belonged to both of them.
But did you see any destroyed property inside the house?
Nothing really destroyed. Things kind of moved around, but I don't know if it was that way before or not.
Right, and was the floor covered in glass?
No, ma'am.
Was the curtain ripped down?
No, ma'am.
Okay. Was there stuff all over the porch?
No, ma'am.
And did Mr. Norris mention to you that he had a black belt?
Yeah, I
recall
think
that?
he mentioned having a black belt in karate or something like that.
Did you see any fishing line or anything wired up on the doors or anything like that at the time?
I don't remember anything like that.
Okay, thank you, that's all I have.
Witness be excused or subject to recall.
Judge, I'd like him subject to recall.
Investigator, you're free to step down and go back out to the hallway, but you're not free to leave the courthouse.
All right, thank you.
Thank you.
Judge, for convenience, I don't imagine he'd be recalled until later. If we can just get him to leave a number with somebody where we can notify him if we think we're going to need him. I don't want him necessarily to be unable to go ahead and work calls when I don't anticipate he'd be called today.
Okay. Sandler, do y'all have a number to reach him?
I have Investigator Colonna's.
Okay. You're free to go today, sir, but you may be recalled, so you're still under subpoena for the rest of the week. All right, they'll reach out if they need you. Thank you, sir. State's next witness.
Elliot Howard.
Just make sure you speak into that microphone. It amplifies and records for us. Thank you.
Good morning.
Good morning.
Can you state your name for the record?
Elliot Howard,
And where are you currently employed?
owner of a business,
Where were you employed back on August 25th of 2021?
Okaloosa County Sheriff's Office.
As a deputy sheriff?
Yes,
Were you on duty that day?
yes.
Where were you on duty?
Work zone 1 and 3, which would be Baker, Holt area.
And on August 25th of 2021, did you receive a call to Wilkerson Bluff Road,
That is correct.
4314 Wilkerson Bluff Road?
Don't know the exact address, but
Is that in Okaloosa County?
yes, ma'am.
Do you remember approximately what time that call was?
It was at night, but I couldn't give you the exact time.
Definitely after the early afternoon.
Yes.
What kind of call was it?
A disturbance, I believe.
Okay. And do you recall who made that call?
Tracy, I believe.
Tracy,
Don't know her last name. Possibly Chesser.
would Tracy Smith sound familiar?
Could be.
Who did you first make contact with when you got there?
Tracy.
And who was the next person you made contact with?
Ronnie, I believe that's his name.
Okay. Do you remember his last name?
Don't
You just
re-
remember Tracy and Ronnie?
Yes, ma'am.
Okay. Do you recognize Ronnie?
Yes, ma'am.
Can you point him out for the court?
Right there in the courtroom.
Okay, and can you point him out, describe an article of clothing he's wearing?
Blue shirt with a red tie.
Okay, let the record reflect that Mr. Howard has identified the defendant, Ronald Norris.
The record shall reflect.
Okay. And Mr. Norris is the second individual that you talked to?
Correct.
Okay. And on that night, were you wearing an agency-issued body camera?
I am.
And would that agency-issued body camera be the best evidence of your interaction with Mr. Norris that evening?
Yes.
And was your agency-issued body camera in working order that night?
Yes.
And did you have it activated during your interaction with Mr. Norris?
Yes.
And when you finished your shift that evening, did you upload that to evidence.com?
Yes.
And that would be a true and accurate representation of your interaction with Mr. Norris that night?
Yes.
Your Honor, may I approach the witness?
Yes, ma'am.
What's been marked as State's Exhibit 5, the timestamps on this have already been discussed.
That's correct, Judge.
You recognize this?
Yes, ma'am.
How do you recognize it?
That is going to be body-worn camera footage. Should be.
And is it a true and accurate depiction?
Yes, ma'am.
Except for editing for time, has it been changed?
No, ma'am.
State moves to admit State's.
Any objections to that, Mr. Williams?
No, Your Honor.
He admitted Exhibit 5, I think you said, Ms. Sandler? He admitted without objection. Any objections to me reading instruction on edited recording 2.2?
No, Your Honor.
Okay. Ladies and gentlemen of the jury, you are about to view a video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way that you view and consider this evidence. All right, you may publish, Ms. Sandler.
Thank you, Your Honor.
On which device will you be playing that? On console?
Yes, Your Honor.
You've got to understand something. You have to help yourself in some of this situation, okay?
Now she's got her cousins involved.
Well,
McComb, I don't know if y'all know him or not.
sounds familiar.
Man, I'm not playing with him. I'll put him in the hospital or the morgue.
Now, Mr. Howard, the relationship between Tracy and Ronnie, as you knew them, that was currently an acrimonious one. Would that be fair to say?
Yes, ma'am.
Now, when you were talking to Mr. Norris, did he tell you that his wife had not been there that day?
Yes, that she had not previously been there that day.
And did you talk to Mr. Norris outside the home?
Yes, ma'am.
Did you talk to him inside the home?
Yes, ma'am.
May I approach the witness, Your Honor? Record reflect, I'm showing it's been marked as State's Exhibit 3. That's Exhibit 4. State's Exhibit 6. State's Exhibit.
The back porch of the house where I first made contact with Ronnie.
How do you recognize
How do I recognize? It's my body-worn camera footage.
it? Okay, is it a true and accurate depiction?
Yes.
And besides being a still, has it been changed or altered?
No, ma'am.
State moves to admit.
Any objections to State's Exhibit 4, Mr. Williams?
No, Your Honor.
State's Exhibit 4 will be admitted without objection.
Let the record reflect. That's what's been marked.
It's the inside, believe, looking into the living room of the home that we were in.
Okay, is this your body cam footage?
Yes, ma'am.
And
Yes, ma'am.
besides being a still from your body,
No, ma'am.
state moves to admit.
Any objections, Mr. Williams, to State's Exhibit 3?
No, Your Honor.
State's Exhibit 3 will be admitted without objection.
Showing the witness what's 6. Do you recognize this?
Yes, ma'am.
How do you recognize it?
Body-worn camera footage of pretty much the same area, but inside the home.
Okay.
Correct.
And is it a true and accurate depiction?
Yes, ma'am.
And besides being a still from your body,
No, ma'am.
state moves to admit.
Any objection, Mr.
No
Williams?
objection.
State's Exhibit 6 will be admitted without objection.
May I publish to the jury?
Yes. Are you using the?
Mr. Howard, can you tell me where you are in the house here?
So if I can see that picture correctly, I want to believe from that back door, if you're thinking about this, you come in the back door of the residence, and there's what I believe to be Ronnie's room where he was staying.
Okay.
And then you go through his room and you turn and go through a hallway. And that is at the end of the hallway looking into a kitchen/living room toward the rear.
Okay.
If
And
I-
is that Mr. Norris on the side of the photo?
Correct.
Okay. And is that a cabinet there in front of you?
Yes, ma'am.
And what was the condition of the cabinet?
It was broken glass, some broken glass laying and stuff there.
Is there broken glass on the floor as well?
Yes, ma'am.
Okay. Was there any other type of debris on the floor that you recall?
I'm sure there was probably stuff out of the cabinet there, but I couldn't tell you exact.
Okay. Officer Howard, can you tell us what we're looking at right there?
Pretty much the same picture you just saw, just a further back angle of it.
And is that the kitchen table?
Yes, ma'am.
Do you recall what was on the kitchen table?
Just some different items that could have been on the wall and maybe some glass from what I remember.
Is that a curtain on the table?
believe so, but I couldn't be completely sure.
Okay, do you recall if there was a curtain hanging on the windowsill when you came in?
No, ma'am.
Okay. What are we looking at in this photo?
So that is the back left side of the residence as you come down a driveway. If you approach the house, you're looking at the front. You have a front porch to your right, and there's like an extension of the house, and this is the back left side of it, kind of like a little staircase that goes up into a back room of the house on the left side.
Okay. And what are we looking at right here?
I believe that was like a notepad.
With a pen on it?
Yes, ma'am.
Okay. Was that next to Mr. Norris?
Yes, ma'am.
Okay, was he sitting on like that little area outside that room?
He was just sitting on a stair, smoking a cigarette when I walked up.
Okay. Now, after you spoke to Mr. Norris, did you go back and speak with Tracy?
Yes, ma'am.
Okay. And who did Tracy have with her?
She had two people with her. She had a female, I cannot remember her name, and she had who I believe to be her cousin. And I could not tell you his name to save my life right now. I completely went mind blank.
Okay.
But I believe it was Tracy's cousin.
Okay. And after you spoke to Tracy, did you close the call out?
Yes.
Okay. So there were no arrests made or anything like that?
No, ma'am.
Okay. And do you recall seeing a gun inside the residence?
No,
when you
ma'am.
walked through?
No, ma'am.
Do you recall whether Mr. Norris talked to you about being a black belt?
No, but it could have happened. I was trying to explain things, and he could have said that, but I don't recall it.
What was his demeanor when you were talking to him?
Agitated.
Okay. And besides that statement to Joe McCombs, did he make any threats against anybody else that you recall?
Without sitting and reading a report or looking at the body-worn camera, no, but I'm sure he made multiple threats between McCombs and his wife. And
Was he complaining about his wife quite a bit
Yes.
during that call?
yes.
And what happened after you left that call?
We have a CAD system, and when we have calls like that, we have to enter what's called call notes. Basically, it kind of gives a brief description. If another deputy goes out there and has no idea what they're dealing with, I give on this date, this time, it's all done up, but I spoke with each person, explain what I do, what I did, and what kind of happened in the call. It's a little bit less than writing an actual report if we have no legal action or something we can do as a deputy. But it gives enough notes and details to provide another deputy that shows up on scene that may not know what happened here, an explanation of what I did so they could be further informed what they can do the next call. And then we have a code sheet, code it out, and then we'll go to our normal call or B10-8 for calls.
Did you receive another call out to the same address?
Yes,
After
very
you left?
shortly later.
What kind of call was it?
It was a shooting.
Okay. And did you respond to that call?
Yes,
Did you go into the home?
yes.
What did you see when you went into the home?
As soon as I made entry to the front porch of the door after we had him in custody, went through the door. As I go through the door, hold the hallway, Joe, I believe, was laying in the hallway on the ground. And then we cleared the rest of the house.
Was Mr. McCombs obviously deceased?
Yes.
What kind of wound did he have?
He had a headshot, shot to the face.
That's all I have. Thank you, Your Honor.
Cross-examination, Mr. Williams.
Yes, Your Honor. The body cameras that y'all use assign a series of numbers and sometimes a letter to indicate that file name is part of that office, or that video camera is coming from a particular officer, correct?
To my knowledge, yes, sir.
Do you recall if yours was X831-09406?
I couldn't tell you that number.
Did you review your body cam footage prior to testifying today?
Yes, sir.
Okay. There are a number of body cams that appear upon review to be yours, based on recognizing your voice, basing on what you described, things of that nature.
Yes, sir.
All right. And so actually, there's not, instead of one continuous file, there's a number of smaller files, correct?
Correct.
All right. And the files are homicide, homicide 1, homicide 2, et cetera. Yours are not numbered in chronological order when you look at the timestamps.
Okay.
Okay? On these body cams, you have a timestamp in the upper right corner.
Correct.
Okay? And y'all are using Zulu time on those timestamps. Is that correct?
I don't know what time. I don't control Axon camera.
Well, to give you an example, homicide-2, which occurs after the shooting. Well, let me go to one that is before the shooting. Homicide-8, which is when you went out for this particular call for service, and starts off with you talking to Tracy. That says the timestamp on at the beginning of it is 005620Z.
Yes.
Z for Zulu.
Okay.
Now, do you know what Zulu time is? That's the same as Greenwich Mean Time?
No.
Do you know that it's, depending on whether it's daylight savings time or not, either 5 hours or 6 hours earlier than the timestamp?
Okay.
Oh, okay. Any rate, this was not at 56 minutes after midnight that you were out there, right?
Okay.
Okay. What about 6 or 7 or just before 8? Would that be more accurate?
Without looking at my paperwork in front of me, I can't recall what time I was out there. That was quite some time ago.
Okay, all right. So, now when you arrived, did another officer arrive with you?
Christian Ginrich.
And was she the supervisor on duty?
She was the corporal on duty, yes.
Okay.
Second in charge supervisor.
And y'all had a discussion with Tracy. You asked about whether or not there were any weapons, and Tracy indicated that there was a shotgun, but she had the shells in the floorboard of her car. Is that right?
Correct.
Okay. And when you met with Ronnie initially, he indicated that he was cleaning the house up.
Correct.
And he had taken certain items, put them on the porch and stuff like that during the course of trying to clean up.
Yes, sir.
Okay. You guys had a discussion about needing to, basically, you've had dealings with both of them before.
Yes, prior.
Okay. And with the discussion about really what everybody needs to do is get a divorce. If they feel like they need an injunction or qualify for an injunction, get that, but that the relationship is toxic and needs to come to an end.
Correct.
Okay. Now, at some point, when you're getting ready to leave, do you ask Mr. Norris, do you need anything from the sheriff's office?
Objection.
Approach, please.
Pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Do you recall asking?
I'm sorry, Mr. Williams, objection's been overruled.
Yes, sir. Do you recall asking that question?
Say the question again real quick.
Do you need anything from the sheriff's office?
Yes.
Okay. Do you recall having a conversation with Mr. Norris about whether or not Tracy Smith still stayed there or where she stays when Mr. Norris is home?
Yes.
Was it your understanding that she was not going to be there that night?
From his point of view, correct.
Okay. Now, did you wind up having another, and again, your videos break up.
Correct.
Did you have a discussion with Sergeant Jenrich about whether or not there was anything else you guys could do?
Correct.
And did that discussion resolve with the decision y'all were going to go 10-8 or be back in service for other calls?
Correct.
Okay. Now, did you wind up having further discussions with Tracy and Mr. McCombs?
Correct.
And would it be fair to say that those discussions were argumentative?
Yes.
Okay. Did both Tracy and Mr. McCombs argue with you on what the law was?
They were trying to explain to me how it was supposed to be. Yes.
Okay. And would it be fair to say that they were both agitated at that time?
Yes. At me.
At you personally?
It seemed because I wasn't doing what they wanted me to do.
And did, in fact, Tracy ask to speak to a supervisor?
Yes.
Corporal Jenrich had already left by that point. Is that right?
She wasn't far down the road, but yes, I had to call her and she came back.
So you called her and she came back?
Yes.
All right. And were you present while she explained essentially the same thing that you'd been trying to explain to Tracy and Mr. McCombs?
Yes.
Did that seem to resolve their agitation at all?
Toward the end of the call, yes.
Okay. Now, did you wind up asking Mr. McCombs a series of questions about how he was going to get home?
Yes.
Okay. Ask him if he had a ride, if he had a vehicle, stuff like that.
Mm-hmm.
Why were you asking those questions?
Tracy kept making the statement that she didn't have no means to get the things that I was asking her if she needed to get. For example, injunctions, different things of that. So I asked him, did he have a vehicle? Did he have a way? Because then Tracy could ride with him, or I was giving examples of how they could get this settled.
Okay. And did she explain she'd had some kind of car trouble or something like that?
Yes.
Now, during the course of your investigation, Did you ascertain that there had been a previous call for service?
Yes.
And that call had been initiated by Mr. Norris?
I couldn't tell you that but I had Miss Ginrich. She was looking at different things of that nature, helping me as a assisting backup.
Okay. Now, did it come about that you explained marital property and that property obtained during the course of the marriage belongs to both parties?
Correct.
And was the short version of all the complaint about damage to property and all of that both of them was making was, it belongs to both of you.
Correct.
There's nothing we can do. Did Tracy then begin threatening to destroy the windows in the marital car?
Yes.
Did she then threaten to burn the house down?
Yes.
Did you have to explain to her that would be an arson?
Correct.
Was there, had both of them been complaining about damage to different phones belonging to each of them?
They were both complaining about, I don't know about specific items, but they were complaining about damaged property on both sides of both parts, yes. That he had damaged her property, she had damaged his property on both sides.
And at some point, did Mr. McCombs interject into it by showing you something that he'd found on his phone, I guess Google search or something like that?
Yes.
Now, at some point, did Deputy Genrich ask in your presence, what is it that you, talking to Tracy, are trying to accomplish tonight?
Yes.
Did Joe respond to her?
I couldn't exactly tell you who responded first. However, she did mention that in front of my presence, but I couldn't tell you exact verbiage back and forth without watching the video or reading my report.
Okay, and that's one reason why I'm asking you.
Yes.
Is it fair to say on these videos, when someone's further away from the mic that's on the body cam that you're wearing, their voice doesn't get picked up as well?
They're pretty good at picking up voices, and they're pretty good.
Okay.
But that doesn't mean that I picked it up. I can't remember it just right now.
All righty. Does at any point Tracy say that she wants to go back up to the house, get her clothes, and get something to drink?
I don't remember the drink portion, but yes, she wanted to go back up to the house to retrieve clothing items and property.
Was there any discussion about y'all, maybe escorting one of them up or escorting Tracy up to get that, arranging, just keeping the peace while that took place?
No. And I explained to her that we would not do that because at that point, when you retrieve property from somebody's home in an instance where there's marital, there's more than likely in a disturbance going to be an argument on who's what and what things belong to who. In that instance, the sheriff's office can't be responsible for going and letting somebody take something that actually belongs to the other person. Then we're at cost for that. So they have where you go get you go file for a motion that we come out and we will assist you, but it has to come from an order from a judge. And without that order, I can't enforce anything. So, and not having receipts or proof of purchase right there, which is not going to happen, a judge will order me to go out and allow her to take these items or have this much time to take these items. Then I can go out there and do what I need to do. But I can't just do it just because she asked. I've got to be court ordered.
So basically, you instruct her to go to the clerk's office and make arrangements for a standby.
Correct, a civil standby.
Okay. Did you try to get Tracy and McCombs to leave and keep them separated from Ronnie for that night?
No, I asked them to leave.
You asked them to leave? Did they indicate to you that that's what they were going to do?
I mean, they didn't tell me they were leaving or not leaving. That's not, I can't force or make or anything, but I try to keep peace. So if somebody's willing to leave, that's great, but it's her property too. I can't force her to leave.
Did you wind up indicating that if you go up there and something breaks out, the people related are going to jail?
Correct.
Let me ask you, did you at some point let Ronnie know either that you were going to try to get them to leave, or that they had been told to leave, or anything along those lines?
No. When I had my contact with Ronnie, and then I went and made contact with Tracy, and then we left.
During the time that you were having contact with Ronnie, was there discussion about where she normally stays when Ronnie is there?
Yes.
And was it, did you express your opinion that, okay, well then, problem solved, she's not going to be here, you're going to be here, y'all need to go get a divorce or injunction or whatever you're going to do?
Pretty much exactly how it was said.
Okay. Judge, that's all the questions that I have. Well, I'll handle the rest of it in due time.
Redirect, Ms. Sandler.
Now, Mr. Howard, this call, this domestic initiated because Tracy believed Mr. Norris was destroying her belongings in the house. Is that correct?
Correct.
Okay. And when you talked to Tracy after you talked to Mr. Norris, it's fair to say she was pretty upset because that was going on.
Correct.
Okay.
And I wasn't able to do anything about it.
Okay. But she calmed down by the end of your conversation, correct?
Yes.
Once you explained everything to her.
Yes, and she had talked to the supervisor.
Okay. So that had resolved by the end of your conversation with her.
Yes.
Okay. And at the beginning, when she was upset, she was talking like, I want to make sure I characterize this correctly. She was upset over the fact that you couldn't do anything, right?
Correct.
So when she was saying, so I can go bust out my windows, it's kind of a way like, wow, that's what I can do.
Mm-hmm.
Okay. So it wasn't like she wasn't storming up there to go bust out the windows, was she?
No.
And she wasn't taking out a pack of matches to go commit arson?
No.
Okay. She was just talking
Correct.
because you couldn't do anything?
Correct.
Okay. Because with the marital property, like you said, anybody can do anything to it. And as a law enforcement officer, there's nothing you can do.
It's a civil issue.
Okay.
Unless someone is hurt or something, I can't do anything legally.
Okay. And for a civil standby, is it the sheriff's office policy that you can't just do one on the fly, correct?
Correct.
Okay.
Unless there's exigent circumstances, which there was not. People
Okay.
had vehicles, people could leave. It's 12 o'clock at night. They're separated. There's no exigent circumstances or children involved that there would need to be something of that nature.
So if you go into a house and, I just want to make sure I get the sheriff's office policy correct.
Okay.
When they're separated like that, you can't say, okay, I'm going to bring you into the house and you grab some of your things and I'll make sure nobody gets hurt. You're just not allowed to do that.
I don't know what policy is now, but back then, yes. You need to have a civil standby if you're going to do one that way. There's no
liability.
There's no liability for the sheriff's office. The judge explains to me directly what you need to do.
So you couldn't help Tracy out that night if you wanted to?
No, ma'am.
And since Mr. Williams brought it up, you did not order Tracy to leave in any way, did you?
No,
Okay, because you can't, because that's her property, right?
correct.
Okay.
They both live there.
Okay. And you did say you would come back if something did break out,
Correct.
and you did come back because something did break out.
Yes.
Okay, and what broke out?
A shooting.
And that was where Joe McCombs was shot, correct?
Correct.
And who was the suspect?
Mr. Norris.
Thank you.
Your Honor, if you'll give me a moment with the state.
Anything else for this witness?
Not at this time, Judge. I do want him subject to recall. Again, this is a witness that we had planned to call, but I don't think we're in a position to be able to put that on until we're putting our case on.
Subject to recall, but not today.
Yes, sir.
Howard, you're still under subpoena. We'll get in touch with you when you need to be back, but you're free to leave today.
Okay.
All right. Thank you, sir.
Judge, if I can inquire real quick. Sir, I was just advised you're not under subpoena. We don't have an address for you because you're a former officer. I anticipate my case is going to go either Wednesday afternoon or Thursday morning. Would you still be available? I appreciate it. If you don't mind, probably you'll be more comfortable giving to the state a phone number where you can be reached, and we'll utilize that and coordinate with you.
Your Honor, may we approach?
Sure. Come on up.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I
got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
All right. Ladies and gentlemen of the jury, at this point, what we're discussing is breaking for an early lunch, and let me explain why. Although we got a little bit of a late start because of things we had to handle, our next witness is going to be pretty lengthy. So instead of breaking up that witness before and after lunch, the court would consider it better to have that witness go all at once. So what we're going to do is release you at this time, have you report back at 12:30, so that gives you a little over an hour to get some lunch, go about your business, but also get back at a time early enough we can make sure we get through the afternoon with the next witness and whoever's next. Obviously, the state calls us witnesses in the sequence it likes to, but we've tried to work on scheduling to not have y'all shuffling back and forth too much. So it might be a little bit early for lunch, but at the same time, I think it's the best way of going about it. So I'm going to release you with the bailiff with one instruction, just the same instruction I've given you previously, which is don't talk to anyone.